Good morning. I hereby call to order this 15th meeting of the Pennsylvania Public Utility Commission for the year 2025. We welcome everyone joining us here in the room today, as well as those joining us on a live stream. Please stand for the Pledge of Allegiance. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forums have been made available for public participation in cases before the Commission, there is no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda is the approval of the minutes of the meeting of July 10th, 2025. I would like to recognize Vice Chair Barrow as the editor of the minutes. Vice Chair Barrow.
Thank you. I've reviewed the minutes from July 10th, 2025, and I move that they be approved as submitted.
I've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfas. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and minutes are approved by a vote of 5-0. Beginning on page 1 of today's agenda, and matters presented by Director Yoder and the Bureau of Audits. I move that the Commission adopt the audit report on Valley Energy's gas cost rate and release the report to the public. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Turning to page 2, and matters presented by Director Hafner in the Office of Special Assistance. I move that the Commission adopt a proposed opinion and order regarding the informal investigation of First Energy Pennsylvania Electric Company. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? I do have a joint motion in this matter with Commissioner Zerfas. I'd ask Vice Chair Barrow to chair the meeting.
Chairman, you are recognized for purposes of your joint motion.
Thank you. We asked our motion be entered into the record as though we read it in its entirety. Before the Commission is a joint petition for approval of settlement filed on March 26, 2024 by the Commission's Bureau of Investigation and Enforcement, or I&E, and the First Energy Pennsylvania Electric Company, who I will refer to as West Penn in this motion, with respect to an informal investigation conducted by I&E. On June 14, 2021, a windstorm caused significant damage to trees and power lines in the West Penn service territory. A total of 15,000 customers were affected. On June 15, 2021, the Commission's Bureau of Consumer Services referred an informal complaint to I&E's Electric Safety Division regarding a storm incident where a West Penn primary distribution line was brought down by a falling tree. The pertinent events detailed on the record include the following. On June 14, 2021, an energized 7,200-volt primary line fell across the carport roof at 586 Arden Road in Washington County. The customer at this residence called 911 for immediate help and then called West Penn for assistance. Following this contact, the customer waited for West Penn to arrive at his home and inform him when it would be safe for him and his girlfriend to evacuate, but no one came to their assistance. As a result of the down line remaining on the carport, the homeowner and his girlfriend were unable to leave their home. Had the homeowner or his girlfriend gone near the carport, the down line could have presented a risk of serious injury or death. The circuit serving the residents of 586 Arden Road, known as the McGovern Circuit, had 4 locations with wires down, including the incident in question. Following the repair of 3 downed wire locations, line crews who were unaware of the circumstances of 586 Arden Road re-energized the McGovern Circuit. This resulted in a bang caused by a short circuit at a nearby fuse and subsequently a de-energizing of a portion of the circuit. I&E and West Penn, the settling parties, have agreed upon the instant settlement. However, the parties agreed that if the matter was fully litigated, I&E was prepared to present evidence that West Penn had violated several provisions of the Public Utility Code and the Commission's regulations, as outlined in our April 15, 2025 order and opinion and order issued at this docket. We highlight the following allegations. West Penn Power failed to ensure that their employees took reasonable steps to perform work pursuant to the company's operating procedures, including a failure of the hazard responders to provide a detailed assessment of the hazardous situation to the hazard dispatcher regarding the facilities affected at the 586 Arden Road residence. West Penn's hazard dispatcher failed to follow up on the line down distress call with another hazard response crew or the customer at the 586 Arden Road residence. West Penn failed to recognize the severity of the energized line down and atop the customer's carport roof during and after the storm event at the 586 Arden Road residence. Pertinent terms of the settlement agreement include the following. West Penn will pay a civil penalty in the amount of $12,500. The penalty will not be tax deductible nor passed through in rates to Pennsylvania customers. West Penn agrees to implement the following corrective actions. Through its emergency plan procedures, it will oversee the wired down reporting process and follow up for reports of line down reports to reduce the risk of contact incidents and property damage in its service area. Supervisors should verify reports of lines down and follow the West Penn procedures to identify and address hazardous situations as quickly as possible and make safe the area from public contact. West Penn shall provide better initial and continued training for appropriate hazard responder personnel on the line down hazard process requirements. Upon initial review of the settlement agreement, the Commission issued our April 2025 order that concluded the record at the time was insufficient. The April 2025 order set out several inquiries about the case to assist in determining if the settlement is in the public interest. The responses provided to these inquiries include additional key information that we find dispositive in the final determination in this proceeding. This information includes the following. The customer first contacted West Penn on June 14, 2021 at 3:57 p.m., reporting a down wire across his carport. The customer then contacted West Penn again on June 15th at 7:25 a.m. to check on the status of the repair and report he still had a wire down on his carport. On June 15, 2021 at 1:15 p.m., more than 21 hours after the initial report, the downed wire at 586 Arden Road residence was repaired and made safe. I&E and West Penn remain in dispute as to whether West Penn ever created the trouble ticket for the reported downed wire atop the carport at 586 Arden Road. Parties represented that after the wire down notification was created by the customer at 586 Arden Road, this was not relayed to the crew in the field, and West Penn crew did not go to the residence. This is not the first incident involving a downed wire in the First Energy Pennsylvania Electric Service territory. In our April 2025 order, the Commission highlighted a number of downed wire events which led to a subsequent investigation, settlement, along with an agreed-upon civil penalty and implementation of remedial measures. These incidents include fatalities caused by down lines on June 2, 2009 and June 26, 2016 at the former Utilities Metropolitan Edison Company and West Penn Power Company, respectively. Our April 2025 order also highlighted a December 12, 2022 incident at Metropolitan Edison Company involving an energized line on a roadway damaging an occupied vehicle. Upon review of the record herein, including the additional information provided by the parties pursuant to the directed inquiries in our April 2025 order, we find it prudent, necessary, and in the public interest to increase the civil penalty from $12,500 to $25,000. Of the utmost concern, the customers at the 586 Arden Road residence placed a call detailing the downed wire on their carport at 3:57 p.m. The issue was not resolved until 1:15 p.m. the next day, noting the customer called again that morning to seek a status update. As the preceding details, they had they attempted to depart the home, they would have been at risk of injury or death. Consequently, the customer and his girlfriend were trapped in their home for over 21 hours. Further substantiating the higher civil penalty is the apparent failure of West Penn to properly communicate the situation at 586 Arden Road to its crews. Such failure is significant insofar as it can be directly tied to why the customer and his girlfriend were trapped in their home for more than 21 hours. since this breakdown in communication resulted in the failure of a crew to timely respond. Compounding our concerns is a further lack of information showing that the customer was kept apprised of developments, therefore leaving the residents legitimately concerned if the downed wire was live and uninformed as to when West Penn intended to fix it. Finally, the record shows that West Penn re-energized its McGovern circuit without knowledge of the situation at 586 Arden Road, resulting in a loud bang caused from a short circuit at a fuse on one of the McGovern circuit poles. We find this increase of 100% of the agreed-upon civil penalty necessary and proper, given the gravity of the circumstances outlined above, along with the company and its previous affiliates' history of similar events. All other provisions of the proposed settlement agreement would remain intact. Therefore, we move that 1, the joint motion for settlement is tentatively approved as modified by this motion. 2, the Bureau of Investigation and Enforcement and First Energy Electric Company, Pennsylvania, as parties to the settlement agreement, shall have 20 days to file a notice of withdrawal from the settlement agreement pursuant to paragraph 33 of said agreement. 3, should the Bureau of Investigation and Enforcement, First Energy Electric Company, Pennsylvania, or both, file a notice of withdrawal pursuant to ordering paragraph number 2 of the joint motion, paragraph number 2, the joint motion for settlement shall be denied and returned to the Bureau of Investigation and Enforcement. 4, should the Bureau of Investigation and Enforcement and First Energy Electric Company, Pennsylvania, not file a notice of withdrawal at this docket, the joint petition for settlement as modified shall be approved. And 5, the Office of Special Assistance draft an opinion and order consistent with this motion. Thank you, Vice Chair Barrow.
You've heard the joint motion. Is there a second? Second. Second by Commissioner Yonora. Any discussion on the joint motion? I do have a statement. It is a verbal statement, so I won't repeat the facts of the case. But I do want to talk about a couple of issues that I see with this settlement. The customer at Arden Road was trapped in their home for approximately 21 hours. I'm not going to say 21 hours in a severe windstorm is too long. That is not my call to make, but I will say that 21 hours without communication from the company after the customer told the company that the line was down is way too long. It's unacceptable that West Penn did not respond or communicate with the customer during this time. Equally concerning, West Penn did not relay the wire down notification to the crew out in the field. So the crew wasn't aware of the down wire, and for that reason, I'm going to assume that's why they were not able to promptly respond to the customer. So our records reflect that this is not the first time a down wire has posed a safety risk to First Energy customers. And in a couple of other cases, we imposed very high civil penalties on the company, $86,000, $1 million. And if a civil penalty is meant to act as a deterrent, it is my belief that we cannot wait until someone is hurt or someone dies to impose that deterrent. You can't deter something after the fact. Because of this fact pattern, because of the prior incidents, I don't believe that the civil penalty agreed to by the parties, even if doubled, is sufficient. Additionally, and just as importantly, the proposed remedial measures, from my point of view, don't include any instruction or sufficient instruction. Notably, the remedial measures include language such as shall oversee its wire down process, shall verify reports of downed wires and shall provide better initial and continued training. All of those are superficial commitments, and frankly, those are things that any of our companies should already be doing. So I don't see what is being done additionally, remedially. I would have preferred to see a commitment from the company outlining a communications procedure for responding to customers who report downed wires on their property so that the customer can stay informed. I'm also not convinced that the proposed remedial measure will address the demonstrated lack of communication between the call center and the field crew, and that's really important. I strongly believe that it should not take a tragic situation or a loss of life for us to impose a significant civil penalty in a situation such as this. This is not the first time that we're dealing with downed wires with this group, this company. And I do not believe that the settlement is going far enough. Thank you. Any further discussion? All right. Hearing none. All those in favor of the joint motion say aye.
Aye.
I will dissent. On final adoption, is there any objection to taking the previous roll call? Hearing none, the recommendation is adopted as amended by the joint motion by a vote of 4-1. Chairman, the gavel's yours. Noting your dissent. Oh, noting my dissent.
Thank you, Vice Chair Barrow. Turning to page 3 of today's agenda, I move that the Commission record the action taken by notational vote on July 28, 2025, via issuance of an opinion and order retaining jurisdiction in the matter involving SCH USA LLC. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. The matter is approved by a vote of 5-0. Continuing on page 3 of today's agenda, I move that the Commission adopt a proposed opinion and order regarding the informal investigation of PPL Electric Utilities Corporation. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion?
Chairman,
Vice Chair Barrow.
Secretary, please enter my conflict statement into the record. Thank you.
Any further comments? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. The matter is approved by a vote of 5-0. Turning to page 4, I move that the Commission adopt the proposed opinion and order regarding the formal complaint of Douglas Smith. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a motion.
Vice Chair Barrow.
Thank you. Please enter my motion into the record as though read in its entirety. The complainant here, Douglas Smith, is a residential customer of PPL who owns a detached garage on his property. In May of 22, the complainant approached PPL about electrifying his garage for the purpose of charging an electric vehicle. Mr. Smith credibly testified that he was never informed by PPL that he could, by reconfiguring the connection to his residential meter, receive service at the lower residential rate instead of the more expensive small commercial rate that was applied to his account. Despite correctly applying its tariff, PPL's service to this customer was unreasonable. The Public Utility Code defines service broadly and is inclusive of not just the delivery of the public utility commodity itself, in this case electricity, it also includes accurate and full communication to customers. I would adopt the ALJ's determinations that A, Mr. Smith never received any suggestion from PPL regarding alternative meter connections that would lower his bill. B, PPL's website inaccurately described its available rates for this customer. And C, PPL personnel are in the best position to know and explain tariff nuances. The tariff, the PPL tariff is public. That shields PPL from claims that the customer could not have known the appropriate rate. That being said, PPL is still responsible for accurately communicating its rates to customers, which I do not believe it did here. Contrary to PPL's claims that customers have a duty to know the ins and outs of the PPL tariff, PPL is by far in the best position to advise customers using only reasonable efforts of the details of electrical setups that benefit the system as well as that customer individually. I would find that PPL did not meet the reasonable effort standard here. I therefore disagree with the conclusion that utilities have absolutely no responsibility to communicate relevant tariff information when interacting with customers for the purposes of new service requests. Accordingly, I agree with the ALJ that imposing a civil penalty of $1,000 against PPL for unreasonable service is appropriate. Another thing I would like to point out, and I won't read the entire motion, is that in February of 2025, the Commission issued our final policy statement on electric utility rate design for electric vehicle charging. That policy statement encourages prioritizing customer education to encourage efficient and effective use of EV charging infrastructure. I know that that policy statement came out after this customer and PPL's interactions, but I do urge PPL and all of our electric companies to follow the guidance in the policy statement in the future. Therefore, I move that the exceptions of PPL to the initial decision are denied consistent with this opinion and order. 2, that the initial decision issued September 26, 2024 is adopted consistent with this opinion and order with this motion. 3, the formal complaint filed by Mr. Douglas Smith is granted in part and denied in part consistent with this motion. And 4, that within 30 days of the entry date of an opinion and order at this docket, that PPL shall pay the civil penalty of $1,000 to the Commission. 5, a copy of the opinion and order that shall issue will be served upon the financial and assessment chief in the Bureau of Administrative Services. 6, that the Bureau of Administrative Services shall monitor this matter for compliance. 7, that if PPL fails to make the payment as required, the Bureau of Administrative Services shall refer the matter to the Pennsylvania Office of Attorney General. 8, that upon payment of the civil penalty, the Secretary shall mark this matter closed. And finally, that the Commission's Office of Special Assistant shall prepare an order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I do have a statement on this case.
Commissioner Coleman.
Thank you. I would just ask that my statement be entered in the record as though I read it in its entirety. I do not agree that PPL provided unreasonable service in this case, and I do not support the imposition of a civil penalty. Therefore, I'll be voting no on the motion. Thank you.
Thank you, Commissioner Coleman. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no.
No?
The ayes have it, and the motion is approved by a vote of 3-2, noting the dissents of Commissioners Coleman and Yanora. On the matters amended by the motion, is there any objection to taking the previous roll call? Hearing none, the matter passes by a vote of 3-2. The matter, as amended by the motion, passes by a vote of 3-2, noting the dissents of Commissioner Coleman and Yenora. Returning to today's agenda, at the bottom of page 4, it should be noted that the the joint application of Appalachian Utilities Incorporated and Pennsylvania American Water Company has been postponed to the public meeting of August 28, 2025. Turning to page 5 of today's agenda, I move that the Commission adopt a proposed opinion and order regarding the petition for declaratory order of the boroughs of Camp Hill et al. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please enter my statement into the record as though I read it in its entirety. This is a petition by several municipalities asking us to declare that they are able to engage in an opt-out energy service program without becoming an electric generation supplier. I don't believe that the request can be granted, but I offer some thoughts about the case. Although I would issue a declaratory order for the reasons provided in my written statement, I would reject the relief requested. I agree with the conclusion in the RISA case that an opt-out aggregation constitutes slamming in contravention of sections 2803 and 2807 of the code and the Commission's regulations. That being said, there is a mechanism by which the municipalities could legally create an equivalent program. Under the Competition Act, the Commission is authorized to designate an alternative default service provider other than the EDC. If that avenue were taken, our regulations presently discuss reassigning the default service obligation for the entire service territory, rather than part of it. In addition, because a default service provider requires a prudent mix of contracts that results in adequate and reliable services at the least cost to customers over time, the municipalities or any moving party would have to demonstrate that their environmentally conscious supply mix meets those standards. Those are not insurmountable challenges, but they are novel. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I also have a statement in this matter. I ask my statement be entered into the record as though I read it in its entirety. Before the Commission are the exceptions of the boroughs of Camp Hill et al. To the initial decision of Administrative Law Judge Mary D. Long, issued on March 28, 2025, at the instant docket. The boroughs filed a petition for issuance of a declaratory order requesting the Commission grant the relief requested in order to, quote, remove uncertainty concerning the lawfulness under Pennsylvania law and Commission precedent of the establishment by each borough of a community choice aggregation program, or CCA program, end quote. The boroughs seek to implement a CCA program permitting municipalities to act as an aggregator for the electric generation service of their residents and procure power on their behalf to achieve favorable pricing, better consumer protection, and other community goals. The borough's CCA program would be designed as an opt-out, in an opt-out fashion, transferring customers to a borough's chosen competitive electric generation supplier if they have not otherwise opted out during a 30-day opt-out period. The petition has garnered significant interest and support from members of the Pennsylvania legislature, including Senator Tim Carney, Senator Amanda Capoletti, Representative Greg Vitale, Representative Mary Jo Daley, and Representative Nancy Gunst. I appreciate the borough's endeavor to tailor retail energy policies and decisions that befit the interests of their communities. The energy landscape is evolving rapidly, and use of the Commonwealth's retail energy marketplace is a powerful tool for customers to ensure the energy they consume aligns with their interests. Nonetheless, the Commission cannot provide relief or facilitate policies that are misaligned with the Public Utility Code. It is well established that the Commission's regulations and orders cannot exceed the bounds of an enumerating statute. The Commission must act within and cannot exceed its jurisdiction. The Commission has considered similar opt-out aggregation proposals in previous proceedings. In a final order entered April 20th, 2006, the Commission provided the relief requested to facilitate a temporary opt-out aggregation program to address an emergency in the Pike County Light and Power Service Territory. That case was prompted by an emergency petition seeking approval to address unusually high electric generation rates. Additionally, in a subsequent proceeding involving the Retail Energy Supply Association, or RESA, the Commission issued a declaratory order consistent with the Pike County decision. In the RESA proceeding, the Commission held that absent emergency circumstances like those present in the Pike proceeding, opt-out municipal aggregation, i.e. the CCA program, violated Section 2807D of the Code. That section of the Public Utility Code provides, quote, "The Commission shall establish regulations to ensure that an electric distribution company does not charge a customer's electricity supplier without direct oral confirmation from the customer of record or written evidence of the customer's consent to change of supplier," end quote. In a well-reasoned initial decision, ALJ Mary D. Long utilizes these facts in order to ultimately substantiate denial of the petition. I concur with ALJ Long. As the initial decision states, the boroughs have not offered a compelling explanation as to why the Commission should deviate from the precedent established in the Pike proceeding and maintain in the RESA proceeding. This precedent, in summary, dictates that absent emergency circumstances like those present in the Pike proceeding, opt-out municipal aggregation violates Section 2708D of the Public Utility Code. As stated by the Pennsylvania Supreme Court and referenced by the Office of Consumer Advocate in its main brief at this docket, quote, "The plain language of a statute is the best indication of the General Assembly's intent, and where the statutory language is clear and unambiguous, we must give effect to the plain language thereof," end quote. I understand and respect the borough's interest in harnessing new tools to achieve their policy goals. Nevertheless, for the reasons explained above, the Commission cannot provide the remedy as sought. I encourage the petitioners to consider aggregation programs utilizing opt-in parameters or to work with the General Assembly to craft legislation permitting opt-out municipal aggregation. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. And the ayes have it, and the matters are approved by a vote of 5-0. Continuing on page 5 of today's agenda, I move that the Commission adopt an omnibus motion beginning with the remaining item on page 5 regarding the formal complaint of the Bureau of Investigation and Enforcement versus J.J. Seraphin, Inc., and continuing the omnibus to include both items on page 6, both items on page 7, both items on page 8, both items on page 9, and a single item on page 10, ending the omnibus with the application of Care Transportation, LLC. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. And the matter is passed by a vote of 5-0. Turning to page 11 of today's agenda, and matters presented by Director Diskin in the Bureau of Technical Utility Services. I move that the Commission adopted an omnibus motion, both items on page 11, beginning with the application of Aqua Pennsylvania wastewater, and continue the omnibus to include all three items on page 12, and both items on page 13, ending the omnibus with the security certificate filing of Consolidated Communications of Pennsylvania. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Turning to page 14, and matters presented by Chief Counsel Screven and the Law Bureau. I move that the Commission adopt a proposed order regarding the petition for relief filed by Alleghenies Broadband Incorporated. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I do have a statement on this case.
Okay, Commissioner, I am going to be offering a motion. Did you want your statement
sorry. I'm
now
sorry.
or want to do it on the motion?
I'm sorry, miscued.
No problem. I do have a motion in this case, and I would ask Vice Chair Barrow to chair.
Chairman, you're recognized for purposes of your motion.
Thank you, Vice Chair Barrow. I ask that my motion be placed into the record as though I read it in its entirety. Before the Commission is the petition for relief filed by Alleghenies Broadband Incorporated requesting a determination that it is not liable to contribute to the Universal Service Fund for 2024. ABI is a certified competitive access provider and a 501c3 nonprofit community-based entity operating in 6 counties in south central Pennsylvania. In 2023, ABI experienced its first positive income since its formation. ABI asserts that all 3 reports where it was required to report its income in 2023, which were filed in 2024, ABI mistakenly entered income received from activities not related to serving end-user customers or in providing intrastate telephone services. The error resulted in an assessment of $61,963.80 for support of the PA-USF. ABI further explained that it experienced its first positive income since its formation in 2023 as a result of consulting fees from local government clients, not from end-user ratepayers. In its petition, ABI attached its 2023 annual report and an affidavit of Jeff Thomas, President and CEO of ABI. No answers were filed in response to ABI's petition. Section 510 of the Public Utility Code requires that by March 31st of each year, every public utility must file a report detailing its gross intrastate operating revenue for the preceding calendar year. Additionally, telecommunication providers are required to submit an affidavit to the PA-USF administrator by March 31st of each year, identifying the provider's total intrastate end-user telecommunications retail revenue for the previous calendar year. ABI timely reported its gross intrastate operating revenue for Section 510 assessment purposes and subsequently paid its Section 510 assessment of $8,644 based on the reported amount. At issue in the petition is the PA-USF assessment form, where ABI reported an identical gross intrastate operating revenue amount as its total intrastate end-user telecommunications retail revenue. ABI submits in its petition and through Mr. Thomas's affidavit that the amount provided in the PA-USF assessment form erroneously included revenue derived exclusively from consulting fees it received for services it provided to local governmental clients, and that the income was not from end-user ratepayers, the provision of intrastate telephone services, or VoIP services. The adjusted total intrastate end-user telecommunications retail revenue would be $0, effectively eliminating the obligation for ABI to pay any PA-USF assessment for 2023. While I acknowledge that ABI completed the verification form as part of submitting its PA-USF assessment form, and the Commission staff emailed ABI to confirm the information provided, I find weight in Mr. Thomas's affidavit, which states that he believed the amount was correct at the time and later learned that it was incorrect. I also find veracity in Mr. Thomas's statement that the revenue was derived exclusively from consulting fees received for services provided to local governmental clients, and that this income was not from end-user ratepayers, the provision of intrastate telephone services or VoIP services. Again, 2023 was the first year ABI experienced positive income since its formation. As the revenue was not related to ABI's total intrastate end-user telecommunications retail revenue, it would be improper for the Commission to assess ABI and collect monies for the PA-USF. In conclusion, I note that ABI is doing critical work in the Commonwealth of facilitating broadband connections for residents and businesses throughout some of the most difficult areas of Pennsylvania to provide such services. I recognize the importance of the PA-USF and ensuring that those entities that owe contributions to the fund pay those contributions. In this case, however, by granting ABI's petition, I seek both to properly fund the PA-USF and encourage deployment of broadband services in the hardest to reach areas of the Commonwealth. Doing so would be consistent with the recent efforts of this Commission to explore how to gain efficiencies in application proceedings. Therefore, I move that 1, the petition for relief filed by Allegheny's Broadband Incorporated on January 31, 2025 at docket number P2025-305-3189 is granted consistent with this motion. 2, that the Law Bureau draft an opinion and order consistent with this motion. And 3, a copy of the opinion and order be served on the administrator of the Pennsylvania Universal Service Fund. Thank you, Vice Chair Barrow.
You've heard the motion. Is there a second?
Second.
Second by Commissioner Surface. Commissioner Coleman, your statement.
Thank you, Vice Chairman. Sorry for getting ahead of myself here this morning. I do have a written statement that I would ask that it just be entered in the record as though I read it in its entirety. I'm going to be voting no on the motion this morning, and that I do agree with the staff recommendation to deny this petition for the reasons that are set forth in my joint statement. Thank you.
Any further discussion? Hearing none, all those in favor of the motion say aye.
Aye.
Aye. Any objections?
No.
On final adoption, is there any objection to using the previous roll call? All right, hearing none, the recommendation is adopted as amended by the motion by a vote of 3-2, noting the dissents of Commissioners Coleman and Yenora. Gavel's yours, Chair.
Thank you, Vice Chair Barrow. Turning to page 15 of today's agenda, matters presented by Chief ALJ Rainey in the Office of Administrative Law Judge. I move that the Commission adopt an omnibus motion, both items on page 15, beginning with the recommended decision of ALJ Haas regarding the petition of Aqua Pennsylvania Incorporated, and ending the omnibus with the remaining matter on page 15, the recommended decision of ALJ Collins regarding the petition of Pennsylvania American Water Company. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the matters are approved by a vote of 5-0. Turning to page 16, I move that the Commission adopt the initial decision of ALJ Haas regarding the formal complaint of Willie Taylor. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a motion.
Vice Chair Barrow.
Please enter my motion into the record as though read in its entirety. I will not read it in its entirety. On November 4th, 2024, Willie Taylor filed a formal complaint against PPL, IGS Energy, and Clearview Electric, alleging slamming. He requested that the extra charges for the unauthorized switch be removed from his account. This case may present the Commission with the novel questions of whether a third-party broker-marketer can be an agent of an EGS in the residential customer space, and how the use of a third-party broker-marketer impacts an EGS's obligation to complete a customer verification upon enrollment. Notably, EnergyBot was not added to the case, and thus a remand is appropriate to add EnergyBot as an indispensable party. Some facts which would aid the Commission in rendering its decision include the relationship between Clearview and EnergyBot, the relationship between Taylor and EnergyBot, and whether EnergyBot completed a verification. Therefore, I move that the initial decision of ALJ Haas dated June 11th, 2025 is affirmed in part and reversed in part consistent with this motion. 2, the portion of the initial decision which relates to PPL is affirmed. PPL is dismissed from further proceedings. 3, the portion of the initial decision which relates to interstate gas supply is dismissed, is affirmed, and IGS is dismissed from further proceedings. 4, the matter of Willie Taylor versus Clearview Electric, PPL, and interstate gas supply is remanded to the Office of the Administrative Law Judge to add Blitz Ventures doing business as EnergyBot as an indispensable party. The scope of the remand shall include, but is not limited to, soliciting facts on the relationships between the parties and the purported verification and enrollment of Willie Taylor by Blitz Ventures doing business as EnergyBot. And 5, the Commission's Office of Special Assistant shall prepare an opinion in order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. You've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the motion is approved by a vote of 5-0. On the matter as amended by the motion, is there any objection to taking previous roll call? Hearing none, the matter as amended by the motion passes by a vote of 5-0. Continuing on page 16, I move that the commission adopt the recommended decision of ALJ Dunderdale regarding the joint petition for settlement of the PUC et al. Versus Peoples Natural Gas Company. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. That concludes our regular agenda for today. Now turning to the carry-in agenda. On page 1 of the carry-in agenda, an additional items presented by the Chief Counsel Screven and the Law Bureau. I move that the Commission ratify the ex parte emergency order that was issued on August 1st, 2025, regarding the petition filed by the Borough of Royersford. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. That concludes all agenda items to be considered today. Before we adjourn, I would like to recognize Commissioner Yanora
Thank
for
you, Chairman.
National Water Quality Month. Commissioner Yanora.
Thank you, Chairman. August is National Water Quality Month, a time to consider how important water resources are to all facets of our life. The Commission continues its commitment to solving challenges facing public water supplies with a focus on protecting treated drinking water from contaminants like PFAS, lead, copper, and Legionella. We work with several agencies and stakeholder groups to increase awareness and understanding about the issues surrounding uses and reuses of water with quality at the forefront. The PUC recognizes the critical role that related water and wastewater utilities play in providing safe and affordable services to communities across the state. We all play part in making sure that the water that comes from our taps is safe to drink. Thank you.
Thank you, Commissioner Yanora. Before we adjourn today, I would like to take a moment to recognize National 811 Day, which we observed earlier this week on August 11th. This is a simple but powerful reminder: before any digging project, no matter how big or small, always call 811. That single step helps protect lives, safeguards our underground infrastructure, and ensure the safety of utility workers, emergency responders, and communities across Pennsylvania. We continue to see far too many incidents involving damaged underground lines, and most of them could have been prevented by following the proper protocols. Calling 811 is not just common sense, it's the law. And thanks to Act 127 of 2024, Pennsylvania's one-call law has been reauthorized and strengthened to improve enforcement and increase accountability for everyone involved in excavation. Also, the PUC's Damage Prevention Committee, which investigates hundreds of underground utility damage cases each year, is now fully self-funded for the second year in a row. Civil penalties assessed against violators cover the cost of these investigations and enforcement actions. So not only is the DPC working every day to promote public safety and accountability, but it's doing so without any added cost to the citizens of the Commonwealth. At the national level, I also want to note that during this summer's NARUC Policy Summit, the Committee on Gas, which I have the honor of chairing, which also includes Commissioner Zerfus, adopted a resolution focused on enhancing the safety of utility field crews. That resolution was approved by the full NARUC Board of Directors, including myself and Vice Chair Barrow, and it reinforces the critical roles that these workers play. Simply adhering to the one-call law can protect utility field workers. As we look ahead to more outdoor work this summer and fall, I encourage all Pennsylvanians, from homeowners to excavators to contractors, to do their part. Call before you dig, wait for lines to be marked, and always dig with care. Thank you. Now, if there is no other business to come before us, is there any objection to adjourning today's meeting? Hearing none, we are adjourned.